attorney LaNthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation of a Lawcast series discussing mergers and acquisitions. In the last 3 Lawcasts in this series, I discussed the responsibilities of the board of directors and in particular, their fiduciary duties related to merger and acquisition transactions. In the last Lawcast, I highlighted Delaware case law on directors' duties. Today, I will drill down on directors' duties when faced with the heightened entire fairness standard of responsibility in a transaction. The entire fairness standard is invoked when a director has a conflict. Delaware's General Corporations Law provides that a contract or transaction in which a director has an interest is neither void nor avoidable if 1. A director discloses any personal interest in a timely manner. 2. A majority of the shareholders approve the transaction after being made aware of the director's involvement. Or 3. The transaction is entirely fair to the corporation and was approved by the disinterested board members. The third element listed by the Delaware statute has become the crux of review by courts. In determining whether a transaction is fair, courts consider both the process, i.e. fair dealing, and the price of the transaction. Courts look at all aspects of the transaction and the transaction as a whole in determining fairness, not just the portion or portions of the transaction involving a conflict. The entire fairness standard can be a difficult hurdle and is often used by minority shareholders to challenge a transaction where they think there may be a potential breach of loyalty or where they think the transaction is not fair to them or where controlling shareholders have received a premium. To protect a transaction involving an interested director, it is vital that all directors take a very active role in the transaction, that the interested director inform both the directors, the other directors, and ultimately the shareholders of the conflict, that the transaction resemble an arm's length transaction, that it be entirely fair, and that negotiations are diligent and active, and that the advice and counsel of independent third parties, including attorneys and accountants, be actively sought. Delaware courts have emphasized that involvement by disinterested, independent directors increases the probability that a board's decisions will receive the benefit of the business judgment rule and will help a board justify its actions under the more stringent entire fairness standard. Independence is determined by all facts and circumstances. However, a director is definitely not independent where they have a personal financial interest in the transaction. Where a conflict exists, most companies obtain third-party fairness opinions. The first element of the statute, i.e. proper disclosure to shareholders, is also of the utmost importance. In the case of a merger or acquisition requiring shareholder vote, it is incumbent upon the directors to provide shareholders with material information necessary to make an informed decision. I'm securities attorney LaNthony, founding partner of Legal and Compliance and producer of Lawcast. Should you want to know more about today's topic, please visit lawcast.com and securitieslawblog.com. Also, feel free to contact me directly. Inquiries of a technical nature are always encouraged.